Welcome to my series on criminal law appeals in Canada. Today we're discussing bail and whether it's possible to get released from custody after trial where a finding of guilt has been made. If you're appealing the case, the answer to that is yes. The appeal court has the power to put the sentence on hold while the case goes through the process and before a final decision is made by the appeal court. The reason for that is because it typically takes several months for an appeal to be heard, sometimes up to a year, and even more if the trial was very lengthy. If a person will have served the entirety of their sentence before that time, or even the bulk of it, it would largely defeat the purpose of appealing. This is referred to as bail pending appeal, and the appeal court will look at factors similar to those considered by the court before trial. So if there's danger to the public or a risk of reoffense, for example, bail would likely be denied. However, in the absence of such concerns or a risk of flight, bail might be granted with appropriate sureties and, of course, conditions. Those conditions tend to be similar to but stricter than the ones in place before trial, given that after a finding of guilt has been made, the presumption of innocence no longer applies. Typical conditions would include a curfew or house arrest, with exceptions for work or study. The big difference between bail pending appeal and bail before the trial is that you now need to establish there's merit to the appeal. This means we must demonstrate an arguable legal basis in support of the appeal, also referred to as grounds of appeal, which are established in the law. It's really a good idea to get a legal analysis and opinion for this, not only for the bail application, but also, of course, for the appeal itself. So what does this mean if you or someone you know has recently been convicted and are considering appeal? Keep in mind that you can't apply for bail until after sentencing has taken place. Of course, you will want to minimize the time spent in jail, but it can take several weeks to prepare a bail application for hearing. So, it's best to get the process started as soon as possible so that the application can be ready and brought quickly once sentence has been imposed. And that concludes today's presentation. I hope it's been useful for you. You will find additional information on bail and other criminal appeal topics on the website. It's www.criminallawappeals.ca. Again, that's all one word, criminallawappeals.ca. Don't hesitate to call or send an email if you have any specific questions, and I'd be happy to discuss it with you. Thanks for tuning in today. Please take good care.